welcome to Navigating Estate Planning with Caress Law. I'm your host, Tammi Caress, and today I am really excited to talk to you about the financial durable power of attorney. And the reason I want to talk to you about this is that I am finding that my clients are having issues with these types of documents often. And I thought it would be a good idea to share with you some things that you can do to ensure that a bank or financial institution will actually honor and accept these documents when the time comes. Typically, that's when you may be in a sudden situation where you have an illness or an accident and you have family members who need to jump in and assist in managing your financial matters while you are under this illness or accident. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. I'm going to get started with what is a financial power of attorney. There's lots of powers of attorneys out there, some for healthcare, some for finances, some for just limited items. But typically, when I am talking about the financial power of attorney, I'm talking more generally, and it's a legal document that grants a person that you trust the authority to manage your financial affairs when you are unable to do that for yourself. This can include paying bills, managing investments, handling banking transactions. It also can include reviewing bills from the cell phone company or the utility company and talking to them if there's an error in the billing, or maybe you need to turn off those bills for the principal. The principal, by the way, is the person who creates this document when they have capacity to do so that if there is a sudden accident or illness, they have already appointed the person that they trust to do this for them. So it's a very, very important document. I mean, can you just imagine if something did suddenly happen to you, an accident, an illness, and you don't have this document in place, then your family members or your loved ones have to resort to a court process in order to manage your financial affairs for you if you can't do it for yourself. And let me tell you, if you've never gone through that kind of process, I really, really, really hope you never have to. It can be lengthy, it is costly, it's expensive, and it's super disruptive. And what I mean by that is most courts, at least I know the courts in Oregon, they require that the person who is incapacitated receive court notice and papers, like actual service. A person is going to hand them legal documents. And if you're incapacitated, that can be super alarming. And if you're not, I mean, it's a good idea to have that requirement in there, because if you're not incapacitated and someone is trying to, take over your financial affairs, you have the opportunity to say, hey, court, I'm just fine. This is not okay for someone else to step into this role. But it is costly because you have to file paperwork with the court. You have to give notice to all relevant parties. Many times you have to pay for a court-appointed person to visit, talk to all the family members, all the loved ones, the healthcare providers, and so forth. And that person will make a recommendation as to who should serve as a guardian or conservator. So if you put a person, or if you name a person in a power of attorney document, hopefully that document will avoid any sort of court process. Let's say that you put your power of attorney together. Great job. I applaud you. Super important to do. However, it may not be enough. And this is where I am running into more and more problems with my clients when they are dealing with financial institutions using a power of attorney. Many financial institutions, their job is to protect your money, your assets, and they have internal policies to do so. They also have legal requirements to do so. And they are going to be pretty zealous, typically, to ensure that they are not in the wrong and they are not taking instructions from someone who truly doesn't have authority to do so. So a bank, when they receive a power of attorney, their back office is going to review it to determine whether or not that power of attorney will be honored and accepted. So why is this a problem? Well, one, it's a problem because if you have an old power of attorney document, then that could be a reason the bank says, or the financial institution says, hey, I am not going to accept this. It's too old. It's too risky for us to accept. In fact, if the bank has just about any reason that they feel that this document may not be valid, maybe it's because they think it could be fraudulent. Maybe they just have a feeling that it's suspicious looking. They really have authority to not honor it. I will tell you, I think this is going to be becoming more and more of an issue for folks because personally, I had to deal with a matter quite some time ago where a gentleman was being taken advantage of by a neighbor. And luckily, he had a relationship with the bank. And so when this neighbor brought him to the bank with this power of attorney, the bank did not accept it. So that turned out to be a good scenario because this neighbor was not acting in the best interest. But nowadays, most people don't know. They don't have a neighborhood bank that they go to and everyone knows them. Many people do their banking online. So I could see this power of attorney becoming, I can see why banks are tightening up on their restrictions on when they will accept a power of attorney and when they won't, specifically because many things, most banking nowadays seem to be online and there isn't that personal relationship. So some things that you can do to minimize the risk that the financial institution may not honor that power of attorney is to ask the financial institution. So once you have met with your estate planning attorney, you've gotten your estate planning documents together, which should include this power of attorney, provide it to your bank and make sure that they have it on file and that they'll accept it. That is one avenue that you can do. The other is update it. The more recent in time that you have signed this power of attorney, I think the better chances that you have the bank will honor it when the time comes. The other option is a lot of financial institutions have their own powers of attorney that the bank uses. The bank has vetted and said, if the principal goes in and uses their document, the bank will honor their document that the principal signed appointing a power of attorney. I know that a lot of financial advisors have their own power of attorney form that they will use that is specific to that institution's banking. My only caveat to this is just make sure it's consistent with the general power of attorney prepared by your attorney. What I mean is make sure you're appointing the same people under those documents. If you're filling out one with the bank and when you have one with your attorney, I don't encourage you to only have a power of attorney with the bank because, again, that will only cover that financial institution. It will not allow your designated agent to access, other financial records and information at institutions outside of the bank that you prepared power of attorney using their form. Another option that you could do is if you have a revocable trust as a part of your estate plan, make sure that your assets in the bank or financial institution are owned by that trust. So many people have heard me talk a lot about revocable trusts and funding the trust. So the reason many people have revocable trust is to avoid probate. And we avoid probate by making sure your assets are not owned by you individually, and instead they are owned by your trust. But another thing that a trust does that a lot of people don't think about is if you are incapacitated and you have a revocable trust and you have made sure that your assets are owned by that trust, your trust document names a successor trustee who has the ability and the authority to manage your financial affairs related to your trust during moments of incapacity. The reason that trusts are better documents when the bank is concerned is that the banks typically are alleviated, if you will. Banks and financial institutions are often more familiar with trust agreements and trust arrangements, and they will accept a successor trusteeship without hesitation. The power of attorney, as I have discussed previously, is much less likely in those types of scenarios. The bank is going to go ahead and scrutinize the power of attorney a little bit more. With the revocable trust, of course, the bank is going to want to review it. They want to make sure that they have what they need to show that the successor trustee is entitled and able to step into that role. Usually that is because either they have the resignation of trustee, and when a trustee resigns, the successor trustee nominated in that trust agreement can step in and they accept that role. Or if it's because the person who created that trust is incapacitated or is no longer able to manage their financial matters, the trust typically will define how that successor trustee steps into that successor trustee role. And the bank wants to see that those requirements under the trust document are satisfied. But they scrutinize those powers of attorney a lot more than the trust documents. Okay, if you don't have a power of attorney, I still think that you need to have one. It is a good idea to do so. If you are one of my clients and I have prepared an estate plan for you, we do have the Family Protector Program, which basically is a program that it's an annual membership, and you, with that annual membership, not only get to talk to my team without charges when things come up, you get discounts off documents when you have changes, and we do not charge you for any changes to the power of attorney or advance directives or HIPAA documents. Those documents we consider ancillary documents to your will or trust. And if you're in my program and you want us to print off a new power of attorney for you and sign it, we'll do that, and it's not going to cost you a thing. So For my clients, Family Protector Program can be a great tool. It's a good way for us to connect every year because with that program, you get a free meeting with me or one of the other team members in my office. All right. So I hope this is helpful to you. I will put a few links below into some other podcasts where I am explaining more about revocable trusts. I'm explaining more about fiduciaries. By the way, your agent under a power of attorney is a fiduciary. So I have some links below with some materials for that. As always, it's been a pleasure for me to relay this information to you. And if you are enjoying these podcasts, I really encourage you to go to my business site. We have a lot more resources. We have free workshops that are on demand for you to even learn more. And you also could give us a 5-star review. We would greatly appreciate that. Thank you, and until next time.